154th meeting, colleagues, and I immediately hand over the floor to Ms. Chang, who will deliver and or coordinate the responses of the delegation to the one or two questions we asked. And I've already been warned by Ms. Chang that things may not always be as orderly as they might hope, and I've tried to reassure her that that's not abnormal. So with that, you have the floor, Madam.
Thank you, Mr. Chairman. I do not dare to warn the chairman per se, but just explaining our difficulties in addressing the many questions, some of which are asking for specific statistics and figures, which I'm afraid we need some time, and we'll provide them once we get them from our base. First of all, I would like to talk about constitutional development. Many members talk about constitutional development with particular regard to how we are seeking to achieve universal suffrage for the election of CE and then for the election of the Legislative Council. Let me begin by reiterating some of the government statements made in this context. In a Green Paper on Constitutional Development published in July 2007, the third-term Hong Kong SAR government made it very clear that in discussing the options for implementing universal suffrage, for electing the chief executive, and for forming the Legislative Council, we must consider, in accordance with the relevant provisions and principles, whether the relevant options can comply with three major principles. A, the basic policies of the state regarding Hong Kong. B, the four principles on constitutional development, namely, meeting the interests of different sectors of society, facilitating the development of capitalist economy, gradual and orderly progress, and being appropriate to the actual situation in Hong Kong. And C, the principles of universal and equal suffrage. The third-term Hong Kong SAR government has also stated in the Green Paper that as far as an individual jurisdiction is concerned, while conforming to the general international understanding of universal suffrage, it can also develop its electoral system having regard to the particular needs and aspirations of its people, the uniqueness of its socio-economic situation, and its historic realities. The current term Hong Kong SAR government will launch comprehensive consultation on the election methods for the chief executive in 2017. I would like to explain if it seems that a member I may have confused a member, that we are starting comprehensive consultation to pave the way for election method for the CE in 2017, and our target is to achieve election by the CE in 2017 through universal suffrage. But in the interim, before 2017, we have the next term Legislative Council coming up, the election of which will be held in 2016. And that one we will need to go through the formalities of public consultation, reforming the Legislative Council electoral method if necessary, subject to consultation findings. So, however, the ultimate goal of achieving universal suffrage in the context of the Legislative Council have to come after the universal suffrage election for the chief executive in 2017. So we will allow sufficient time to conduct comprehensive consultation for the upcoming two elections, one for the CE in 2017 and the other for the LegCo in 2016. And we will initiate all the constitutional and legal procedures at an appropriate juncture. We will ensure that the community of Hong Kong will have sufficient time to forge consensus on the universal suffrage models for the CE in particular when the coming election in 2017 is due. And afterwards, we will seek to achieve election of the Legislative Council through universal suffrage. Now I would like to invite the Solicitor General in briefing, in going over the legislative provision and the requirements in the Basic Law and in what we call the 2007 decision as to how we are seeking or ensuring the election methods in the coming CE election and then the legislative election when we talk about universal suffrage. Can I invite the Solicitor General?
Thank you, Mr. Chairman. I'm very pleased to be able to explain to the committee the progress for universal suffrage for election of the Chief Executive in 2017 and also the universal suffrage election of the Legislative Council in 2020. This is indeed a very exciting time for Hong Kong because the 2007 National People's Congress Standing Committee's decision has actually set out this timetable for us to look at, and then we can, in relation to the timetable, work out a mechanism for implementing universal suffrage in Hong Kong. The 2007 decision of the MPCSC also provided for the different legal procedure for arriving at the final mechanism for universal suffrage. Ms. Chang, my delegation leader, has just explained to you that there are certain principles that we have to have regard to in designing our electoral system. And some of these important principles are built into the Basic Law of Hong Kong, such as meeting the interest of different sectors of our society, facilitating the development of the capitalist economy, gradual and orderly progress. These are all principles set out in our Basic Law. And what the Basic Law article specifically says about the election of the Chief Executive by universal suffrage is in Article 45 of the Basic Law. And I think the most relevant sentence that I should read to you is that there is a sentence in there saying that the ultimate aim is the selection of the Chief Executive by universal suffrage upon nomination by a broadly representative nominating committee in accordance with democratic procedure. We do appreciate that the whole exercise of designing the system has to wait until the government come forward with a consultation exercise. But in terms of implementing universal suffrage for election of the CE and the Chief and the Legislative Council of Hong Kong, we will bear in mind those important principles that I have just cited, and we have also listened to some of the intervention earlier that there are some important principles about universal suffrage in the very valuable General Comments 25 of the Human Rights Committee. And we will also have regard to those principles in designing the system. And right now, it may be too early because the timetable for consultation is to be set by the government, and that will be announced when the government is ready to do the consultation. But the timetable, the big timetable is there. That's 2017 for the Chief Executive, and thereafter 2020 for the Legislative Council. That's my supplement to what Ms. Chang has just said. Maybe before I finish with my intervention, I should also mention a point that was mentioned by Mr. Flinterman earlier about the reservation that Hong Kong consider as being applicable still at this current moment, and that's the reservation in relation to Article 25B of the ICCPR. Of course, we note the different opinions of the Human Rights Committee on that particular reservation. We have explained our position very clearly in the past. Because of the specific circumstances under which the ICCPR was applied to Hong Kong before the transfer of sovereignty in 1997 and after, and also because of the specific provision in the Basic Law, that provision which I've just read to you about gradual and orderly progress in relation to universal suffrage. We consider that it's important for Hong Kong to preserve that reservation for us as to when that reservation will be reviewed for Hong Kong. It's a matter for the future. I think it's a matter when Hong Kong has actually implemented universal suffrage in the timetable that I've just set out. Thank you very much, Mr. Chairman.
Sorry, the last small question about constitutional. The last question about constitutional development vis-à-vis functional constituencies. I would just like to reiterate that the Hong Kong SAR government has not taken any position on the future of the functional constituencies as yet. This is an issue which requires extensive deliberations and consensus among the community of Hong Kong in due course, and we will certainly deal with it when we come to discussing the electoral method for forming the Legislative Council, through universal suffrage after the election of CE is done in 2017. So may I now turn to questions about rule of law and the interpretation of basic law. Can I invite the Solicitor General to go over this area with us?
Thank you, Mr. Chairman. There was a question just earlier on how the interpretation power of the National People's Congress, of the Standing Committee of the National People's Congress, might affect the rule of law in Hong Kong, or something to that effect. I should take this opportunity here to explain to the committee the mechanism for interpreting the basic laws through the Standing Committee of the National People's Congress. Maybe the background to this question, I think it's a key to our understanding, is the fact that Hong Kong comes directly under the Central People's Government of China. Hong Kong is a special administrative region of China. Hong Kong is not like other systems whereby in a federal system you might find a place, a jurisdiction where judicial power are shared between the central government and a regional government. But in Hong Kong and in China, Hong Kong is constitutionally directly under the Central People's Government. So there's no question of Hong Kong owning some residual power in itself. So all the powers given to the Hong Kong SAR, including Hong Kong SAR Court, is given on the basis of what is in the Basic Law. And the Basic Law is very clear about the interpretation of the Basic Law, the power of interpretation of the Basic Law. Article 158 of the Basic Law says the power of interpretation of this law shall be vested in the Standing Committee of the National People's Congress. And the Standing Committee of the National People's Congress shall authorize the courts of the Hong Kong SAR to interpret on their own in adjudicating cases the provision of this law which are within the limits of the autonomy of the region. So it's quite clear from our constitutional framework that the power of interpreting the Basic Law rests in the Standing Committee of the National People's Congress. But how does it affect Hong Kong's rule of law as a whole? I would say that since the handover in July 1997, the rule of law in Hong Kong, independent judiciary in Hong Kong, has been one of the most important factors for Hong Kong's success. We are not unduly affected by interpretation made by the Standing Committee of the National People's Congress in the past 15 years. There have been 4 occasions on which the Standing Committee interpreted the Basic Law. And I think the last time when we come before this committee, we reported to the committee that the Standing Committee of the National People's Congress made 3 interpretations, some of which were made upon the request of the Hong Kong SAR government. Since the time of the last report, there was just one occasion when the National People's Congress Standing Committee interpreted the Basic Law, and that was upon the request of the Court of Final Appeal in Hong Kong. And that was done on the basis of Article 158, Paragraph 3, which provided that the Hong Kong CFA, the Hong Kong Court of Final Appeal, may, in adjudicating cases, when they have to interpret a provision relating to the responsibility of the Central People's Government, before they made a binding judgment, they are under an obligation to make a referral to the Standing Committee of the National People's Congress, and they did that time, and that was in the year 2012. And on that occasion, because the interpretation question was on the question of state immunity law in Hong Kong, and we all understand that the basis for state immunity is very much based on foreign and external affairs. So on that occasion, I think the people of Hong Kong generally accepted that it was legitimate and also reasonable for the Standing Committee of the National People's Congress to make that interpretation. These are the only 4 examples. We do understand that there are much concern within the legal profession, within the public of Hong Kong, that the National People's Congress Standing Committee should not likely utilize the power to interpret the basic law. And that is something which I think we have borne in mind when we consider the question of interpretation. And the government has been very careful to make sure that unless in exceptional circumstances, it would not make any requests to the National People's Congress Standing Committee to interpret the basic law. I should end by quoting a passage from a judgment in the case of Lau Gong-yong and Director of Immigration that was decided in 1999. And the interesting statement that I'm going to quote is made by Sir Anthony Mason, a non-permanent judge of the Court of Final Appeal of Hong Kong. Sir Anthony Mason is, of course, the former Chief Justice of Australia, and he served in our Court of Final Appeal as a non-permanent overseas judge. And he has this to say when he looks at the provision in the Basic Law regarding interpretation, the interpretation power of the National People's Congress Standing Committee. He said this: as in the case with constitutional division of power, a link between the courts of the region and the institution of the PRC is required. In the nationwide common law system, the link would normally be between the regional courts and the National Constitutional Court or the National Supreme Court. Here, in Hong Kong, however, there are not only 2 different systems, but also 2 different legal systems. In the context of one country, 2 systems, Article 158 of the Basic Law provides a very different link. That is because the article, in conformity with Article 67(4) of the PRC Constitution, vests the general power of interpretation of the Basic Law, not in the People's Supreme Court or the National Court, but in the National People's Congress Standing Committee. And he also said that this conclusion may seem strange to a common law lawyer, the conclusion that the Standing Committee of the National People's Congress should have the power to interpret the Basic Law. He said this may sound strange to a common law lawyer, but in my view, it follows inevitably from a consideration of the text and structure of Article 158, viewed in the light of the context of the Basic Law and its character as the constitution for the Hong Kong SAR embodied in the national law enacted by the PRC. So, although a lot of people may have concern about the exercise of the power to interpret the Basic Law by the National People's Congress Standing Committee, it's a question of how that power is exercised. And in Hong Kong, the government is very, very mindful of the views of the public in looking at the interpretation by the NBCSC. So we try to avoid interpretation by the Standing Committee as far as possible. And so far we have been successful. So in the last, since the last meeting of the committee, there has been no interpretation which was initiated by the National People's Congress Standing Committee. The only occasion that I said earlier was an occasion when the CFA, the Qualifying Appeal in Hong Kong, actually referred a question of the basic law to the National People's Congress for interpretation. Thank you very much.
Chairman, if I have your permission, I would like to proceed to talk about the proposal for a Commission on Human Rights in Hong Kong. We have provided in our responses to the list of questions and stated our view that what matters is how the Hong Kong government safeguard human rights through legal and administrative network. In our case, we have ensured the protection of human rights through legislative safeguards, which are enshrined in the Basic Law, the Hong Kong Bills of Rights Ordinance, and other relevant ordinances. These pieces of legislation are buttressed by the rule of law and an independent judiciary. In our existing institutional framework, we have a number of statutory and fully independent commissions or organizations undertaking different aspects of core elements of human rights, including the Equal Opportunities Commission, the Privacy Commissioner for Personal Data, the Ombudsman that deals with maladministration by the government, and a low-limit legal aid services. Hence, in our view, our arrangement for separate statutory bodies to look after human rights issues will not and does not adversely affect or lessen the protection of human rights afforded to the people of Hong Kong. Now I would like to turn to the Convention Against Torture, with particular regard to a recent court case called Upamaka, as to what its implication will be on our implementation of the Convention Against Torture. And on that count, I would like to invite Mr. Billy Wu to brief the committee.
Thank you, Chair. In response to Mr. Newman's several questions in regard to our developments on handling torture claims made under the Convention Against Torture, and also the latest judgment by our Court of Final Appeal in the Upamaka case, we fully respect the court's judgment in the Upamaka case, and we will definitely continue to act in accordance with the law. That includes statute and case laws in the exercise of powers and the enforcement of duties in relation to our immigration control. And accordingly, that is according to the Upamaka judgment, if a deportee can sufficiently establish that he will face a real risk of being subjected to torture or to cruel, inhuman, or degrading treatment or punishment. These are the inhuman treatment that we refer to, and that is also a violation of ICCPR Article 7. Once sent back to another country, it will constitute a ground for restraining the Immigration Department from proceeding with the deportation. As this committee has already duly noted, we just introduced a statutory system for screening torture claims commencing December last year. We are now studying the CFA's judgment in Upamaka in detail, and also seeking legal advice and drawing reference to other overseas experience as to how CIDTP, or the inhuman treatment, has been protected, and we are actively exploring the various possible options to follow up with the Upamaka judgment to ensure that the Immigration Department acts in accordance with the requirement of the law in the exercise of powers and the enforcement of duties in relation to immigration control. I would just like to add that we also note that the court's judgment has clearly pointed out that a person making such a claim against for protection against inhuman treatment must establish that once expelled, he would face a real risk of being subjected to torture or this inhuman treatment, and the risk shall attain, in quotes, a minimum level of severity, and such claims has to pass again, in quote, very high thresholds before it is accepted or as substantiated. And just a note on background, over the years in discharging the deportation or removal duties, if a person claims that he will be subjected to torture or to inhuman treatment upon deportation or removal, the Immigration Department has always considered in detail and in accordance with the law any reasons that that person had raised against deportation or removal, and decide whether to execute the removal or the deportation, or to exercise discretion to temporarily withhold the deportation or removal actions. And these are my updates on the subject.
Perhaps I could now turn to women participation. There were concerns about women participation in Hong Kong other than in advisory board and committee. While we have achieved our target of meeting 30% of members participating in Hong Kong's advisory board or committees, actually we have achieved 33% as at last year. Of course, we will seek to do better continuously. But in other areas, I would like to brief the committee that while we fully recognize that education is a cornerstone facilitating equal opportunities for women, we note that the number of female undergraduate students in tertiary education institutions is consistently more than male undergrads over the year. For example, in 2011 to 2012, there were some 30,000 female students versus 27,400 male students among the 8 publicly funded or university grant committee funded institutions. And in the civil service, the percentage of female civil servants has increased from 33.7% in 2006, when the committee made its last observation, to 35.7% last year. The percentage of female directorate officers has also increased from 29.2% to 33.8% during the same period. Of note is that the percentage of females at permanent secretary level, i.e. my level, which is the most senior rank in the civil service, the percentage of females at permanent secretary level, which is the highest rank, stands at 47% currently. So we would like to assure the Commission that we are making our best endeavor in encouraging women participation in public affairs in civil service. As to whether or as to why we may not be able to achieve the same percentage in terms of percentage of women legislators, for instance, it is perhaps a matter of judgment by individual citizens of Hong Kong. But in a way, we pledge to enhance and to continue to encourage women participation in all arenas of lives in Hong Kong. There were also questions about the use of force, particularly by the police, whether it constitutes torture or ill treatment, or why the small number of complaints, for example. On that respect, can I invite Mr. Patrick Hudson from the police force to brief us on the situation?
Thank you, Mr. Chair. If I can, first of all, draw attention to the issue of allegations of assault. There is no distinction of any reports of an assault, whether it's allegedly being committed by a police officer or any other person. Any complaint that has been made of an assault will be in the first instance subject to a criminal investigation. And as with any other criminal investigations, this will require examination of the evidence, including witness testimony and medical reports available. I may move now on to the issue of use of force. The police have very clear guidelines and training for officers which provide that only the minimal force necessary to achieve the purpose may be used, and that force used must be reasonable in the circumstances. The principles governing the use of force by the police are: only the minimum force reasonably necessary to achieve a lawful purpose may be used, and once that purpose has been achieved, the use of force shall cease. When circumstances permit, police officers shall give warning of the intention to use force and of the nature and degree of force that they intend to use. And persons shall be given every opportunity, whenever practicable, to obey police orders before force is used. Turning specifically to observations with regard to the use of OC foam, any use of force, including the use of OC foam, is subject to review, and an officer must account for his use of force. In regard to the use of OC foam, a superintendent-ranked officer will assess the circumstances of the discharge to ensure of the discharge and to ensure the justification thereof. Thank you, Mr. Chair.
There are a number of questions about race discriminations or the protection of ethnic minorities. I would like to try to deal with them one by one. There was a question about why new arrivals from the mainland are not covered by our new race discrimination ordinance. Actually, this was a topic debated vigorously in the Legislative Council when it scrutinized the draft bill. As a matter, with the ordinance now enacted and approved by the Legislative Council, under the ordinance, race in relation to a person means the race, color, descent, national or ethnic origin of the person. The definition of race is in line with the definition under International Covenant on the Elimination of All Forms of Racial Discrimination and is widely adopted internationally. From the perspective of protecting against racial discrimination, the ordinance applies equally to all persons in Hong Kong, including new arrivals from the mainland, and safeguards their rights against discrimination on the ground of race. In fact, the vast majority of new arrivals from the mainland are of the same ethnic origin as that of most permanent residents in Hong Kong, although there may be differences among some in accent, dialect, or certain personal habits. However, such differences are not based on race and do not distinguish them as a separate racial group. Defining new arrivals from the mainland as a distinct racial group by statute would be inconsistent with internationally accepted practice and standard, and is difficult to enforce anyway. Another question about why are laws on nationality and immigration exempted under race discrimination ordinance. Article 1.3 of HRCtte, the Convention on Elimination of Racial Discrimination, HRCtte. Article 1.3 of HRCtte states, inter alia, that nothing in this convention may be interpreted as affecting in any way the legal provisions of states parties concerning nationality, citizenship, or naturalization, provided that such provisions do not discriminate against any particular nationality. Similarly, immigrant status is not a prohibited ground of discrimination under HRCtte. The exemptions of nationality and immigration laws under our race discrimination ordinance make it clear that the ordinance does not interfere with any domestic legislation governing nationality, citizenship, resident status, or naturalization. There were also questions that in seeking convenience, some of our lawyers may be more inclined to encourage their client, which are of ethnic minority origin, to plead guilty. This is certainly unfounded and is against the lawyer's practice professional ethics. And on that count, may I invite our Solicitor General to talk about this question.
I think this is a very specific instances that some NGO might refer to, but we certainly have not been advised of any particular cases when this happened. My personal suspicion is that this rarely happens because from a lawyer's point of view, a lawyer generally has to act in accordance with the instructions of his clients, and it would be contrary to professional code of practice for solicitors and barristers in Hong Kong if the lawyers persuade his client to plead guilty just for his own convenience and maybe because he wanted to avoid trouble, defending people from our ethnic minority. This, I think, is something which is rare in Hong Kong, and if there are examples of such instances, we would very much like to hear them and follow up on these cases.
There are concerns about the protection of migrant workers. We call them, most of them are foreign domestic helpers in Hong Kong. A particular question was raised about the 2-week rule, i.e. in between employment contracts, each lasting for 2 years. A foreign domestic helper was required to leave Hong Kong back to her home country for 2 weeks. So we call it the 2-week rule. The 2-week rule applies when the employment contract of an foreign domestic helper is prematurely terminated. Under such circumstances, the foreign domestic helper is permitted to remain in the Hong Kong SAR for the remainder of the permitted limit of stay or 2 weeks from the date of termination of contract, whichever is the shorter. This policy does not preclude the foreign domestic helper from applying to work in the Hong Kong SAR again after returning to his or her place of origin. The 2-week rule is essential and required for maintaining effective immigration control and eliminating chances of foreign domestic helpers overstaying in Hong Kong or working illegally after termination of their contracts. However, if a foreign domestic helper whose contract is prematurely terminated may be allowed to change employer in Hong Kong without returning to his or her place of origin, if they meet the relevant criteria, including that his or her employer is unable to continue with the contract because of migration, external transfer, death, or financial reasons, or there is evidence that the foreign domestic helper has been abused or exploited. So there must be good reason that a foreign domestic helper can stay in Hong Kong, notwithstanding the 2-week rule. But there is the immigration control reason and policy that mandates, that require us to continue to enforce the 2-week rule in Hong Kong. There were also concerns or questions about Equal Opportunities Commission with regard to the composition of the selection board for recruiting the chairman for the Equal Opportunities Commission. May I explain that the selection board for the Equal Opportunities Commission chairperson recommends the only and paramount important criteria is to recommend the most suitable candidate for the appointment to the chief executive based on a set of objective criteria, which we publish in recruiting the chairperson candidates. The board itself comprises prominent members of the community with knowledge and experience in equal opportunities, medical, corporate governance, community services, and related fields. One of the members is also a person with disabilities himself. The selection board assesses candidates in a fair, open, and impartial manner and recommend only the most suitable candidate to be the EOC chairperson for appointment. As to the selection board, we cannot state on behalf of the selection board as to why the chairperson was selected. But the most important attributes of the EOC chairperson would be his integrity, commitment to and vision on equal opportunity issues, as well as his management and administrative experience in leading the Equal Opportunity Commission to fulfill its statutory functions under the relevant ordinances. May I now turn to in protecting ethnic minorities, there were accusations that interpretation, for example, in the census and statistics exercise was not provided. In the 2011 population census, which covered the whole population of Hong Kong, the Census and Statistics Department had implemented comprehensive arrangements with regard to breaking language barriers so that ethnic minorities can devote themselves to the project. The major measures implemented include, before census was conducted, the Census and Statistics Department will have provided training to all enumerators to make sure that they are equipped with the required knowledge and skills in handling households of ethnic minorities. The department also strengthened contacts with NGOs serving ethnic minority groups to ensure that ethnic minority groups get the message about the census and statistic exercise and arrangements. They also introduced the census exercise to ethnic minorities groups through widely publicized posters in multi-languages in service centers under the Social Welfare Department and NGOs, and placing advertisement on ethnic minorities newspapers and at radio programs. They would also test enumerators' handling capacity of households of ethnic minorities during the pilot survey of the census. In fact, during the census period, to facilitate enumerators to communicate with households with ethnic minority members, in particular those households with all ethnic minorities who are not familiar with Chinese or English. The department provided enumerators with a prompt card, which contains simple introduction of the census exercise in 11 most commonly spoken minority languages, and a set of notes for respondents printed in 11 languages, which contain detailed information to introduce the census exercise to the household and to remind the household to require interpretation service if they so desire and need. So there are comprehensive measures before and during the census exercise to ensure that minority groups' households will not be taken out or removed or brushed aside in the population census. There were also questions about interpretation for ethnic minority clients when it comes to legal aid services. The legal aid department arranges free interpretation service for applicants who do not speak English or Chinese to help them with the application process. It has published a series of leaflets on legal aid in 10 ethnic minority languages. I wouldn't bother members with the dialects or different languages here, but they are commonly spoken in Hong Kong. And if clients do not speak English or Chinese, LAD will provide an interpreter. The leaflets, together with the other leaflets, are available at offices of the Legal Aid Department, and they can be downloaded readily from the Legal Aid Department's website. Such information is also available at relevant consulate offices, the Judiciary's Resource Center for Unrepresented Litigants, police stations, public inquiry service centers of the Home Affairs Department, premises of the Labor Department, the Correctional Services Department, Social Welfare Department, and public hospitals. So in effect, we have a policy of requiring especially government departments and statutory bodies to look after the interests and service needs of the ethnic minorities by breaking language barrier in the very first instance. And we welcome suggestions as to how much further we can do or should do in this area. There are other questions which I would beg the chairman's forbearance for providing them later, either if we can have the information tomorrow or later in writing.
Thank you, Madam Chang. That's absolutely fine. No forbearance required. We look forward to receiving it as and when you can provide it. And now I propose to make use of the final few minutes for colleagues to ask follow-up questions. Mr. Flinterman, you have the floor, sir.
Thank you very much, Mr. Chairman. I would like to express my gratitude to the delegation, to the head of the delegation, and the other members of the delegation for their replies to the many questions that we have raised. I would like to come back to the issue which was called by Madam Head of Delegation constitutional development. I was very grateful for the answer and for the reflections by the Solicitor General on the issue of the reservation to Article 25, paragraph B. And given the fact that, among others, the World Conference on Human Rights, Second World Conference on Human Rights of 1993 has requested all human rights treaty bodies in their constructive dialogues with states parties to their respective international human rights instruments, has mandated human rights treaty bodies to discuss the issue of reservations in depth with a view to urging the withdrawal of reservations or to make reservations narrower. I would like to come back to the explanation given. At the time, in 1976, the UK entered a reservation to the effect that Article 25B would not oblige the state party to establish a legislature in Hong Kong at that time in accordance with Article 25. It has been the view of the Human Rights Committee that since there is now a legislative council, that the reservation lost its impact. Another interpretation has given by the by Hong Kong SAR, but I am still puzzled on the reasons given. We have been informed that there is a full commitment to realizing universal and equal suffrage for the election of the Chief Executive and the Legislative Council. But that exactly is the thrust of Article 25. We have been further informed by the Solicitor General that in further substantiating the terms equal and universal suffrage, guidance will be sought, among others, from the general comment on Article 25. So, given this background, my question is, isn't it clear that the reservation is superfluous? Or, if not, could the delegation in a position to reflect on the reasons for maintaining the reservation?
Thank you, Mr. Flunterman. Do any other colleagues seek the floor? I don't see it. Maybe then the chair could allow himself just to seek one small point of clarification around the same issue. Mr. Flinterman has asked about the legal implications of the reservation and universal suffrage. I want to ask a question about the timing. I think I've got it straight, but I'd like to be sure I've got it straight. This is not a question about the timing of consultations, it's about the timing of the result. Am I clear that the commitment is to universal suffrage elections for the Chief Executive in 2017, universal suffrage elections for district councils in 2016, and universal suffrage for LegCo in 2020? Do I have that correct? Thank you, Madam. And I can return the floor to you already, given that that's the end, seems to be the end of our questions.
Chairman, if we may, we can address your question, since this is the only question coming from you today. And we will leave the question about reservation tomorrow. When we have fresh mind, fresh body, we'll answer that question with vigor. On free timing, elections or targets for free elections, the elections of district councils, the local councils, are already conducted through one person, one vote arrangement. So In the basic law, the crux of the matter is about the election methods for the chief executive and the election method for the Legislative Council. The National People's Congress decision made it clear that we should achieve the target of electing the CE through universal suffrage in the election of 2017. After this is achieved, then the election of the LegCo may be elected through universal suffrage. And in Hong Kong, the timetable dictates that after 2017, the immediate LegCo election will be conducted in 2020. So 2020 will be our target, our timetable, our target to achieve universal suffrage to elect all members of the Legislative Council.
Thank you very much, Madam Chang. I prefer your words to the words of the National People's Congress, and may be and should that don't necessarily aren't very clear to me, but a clear target that these are when it's supposed to happen. That's say 2017 for the chief executive and 2020 for LegCo. I take it that that is what we are expected to take on board as what is likely to happen, and what the I'm not quite sure what the terminology is for a territory, an autonomous region, but I guess the state party, and the state party is the People's Republic of China in this connection, that the state party will ensure that the state party is aiming to have elections on the dates that we've just mentioned. And I see you nodding, Madam Chairperson. That's a very helpful clarification. And with that, we're now at the end of the session for this afternoon. We'll continue tomorrow with the next round of questions. That's from question 14 through to the end, question 27. That's a issue 14 to issue 27. When we will ask, our colleagues will ask the questions, the delegation will then respond, and the same process as we've had today. And meanwhile, I thank the delegation very, very much for all its well-organized and well-focused replies.